Hello, everyone. During this coronavirus crisis, there is a lot of uncertainty out there in terms of what the obligations for the employers are towards their non-immigrant employees. Obligations when it comes to I-9 verification, furloughs, layoffs, as well as making material changes to the terms and conditions of their employment. So I will be addressing some of those issues in this video. I will also be addressing LCA posting guidelines when the place of business and the place of employment are closed due to the current pandemic, and you have temporarily asked your workers to work from home. These are just some of the common issues that our clients are facing today, so I thought I'll address them all in one video. A few things to consider before we get into anything specific at this time is just treat all your employees the same, regardless of visa status or nationality. Also, if you're considering a furlough, just keep good documentation of everything. How long the furlough lasted, why it's occurring. For example, the governor of New York ordered all non-essential employees to stay home, and your business was considered non-essential. The first thing we're going to talk about I-9 verification. The Department of Homeland Security has announced some flexibility in the I-9 verification process when it comes to employers and workplaces operating remotely. Please note that at this time, there are no exceptions for employees that are physically present at the work location. For employees that are taking physical proximity precautions due to COVID-19, employers will not be required to review the employee's identity and employment authorization documents in the employee's physical presence. However, employers must inspect these documents remotely. That is either maybe over a video link, via fax, via email. And once normal operations resume, all employees who were then onboarded using remote verification must report to their employer within 3 business days for an in-person verification of identity and employment eligibility documentation. Employers who avail themselves of this option must provide written documentation of their remote onboarding and telework policy for each employee, and this burden unfortunately rests solely with just the employers. Next comes furloughs. This is something that a lot of companies might be considering in this time of uncertainty and a potential decline in revenue. Just to differentiate between a furlough and a layoff, a furlough is more temporary leave of absence, which is generally shorter in duration. During a furlough, the employees, although they're not paid, but they're still technically employed. And when the business reopens, furloughed employees generally become active again. A layoff is a more permanent long-term solution. So if you're considering a furlough, note that there is and you have H-1B workers, note that there is H-1B regulation out there that states that a worker who is rendered unable to work due to no fault of his or her own or due to conditions unrelated to employment, maternity leave, taking care of a sick relative. In these cases, employers are not obligated to pay the required wage rate during that period. However, the catch here is that a shelter-in-place policy or an order by the government may not exactly fit the furlough exception. So the employee could file for back wages due to a violation of the LCA's terms and conditions, in which case the employer could be subject to payment of back wages and penalties. Another option here is a layoff option, but under the current regulations, this requires the employer to notify USCIS of the termination of the H-1B worker's employment and also providing return transportation. In this case, rehiring would also not be as straightforward as in the case of a furlough, since you have to file a new petition with USCIS, with new filing fees, etc. Due to a lack of guidance from USCIS and the Department of Labor in this situation, we highly recommend reaching out to an immigration attorney before making a decision as to which option you want to exercise. Another option that employers could be considering is a reduction in work hours for their employees. While this may not be considered a huge deal for your regular employees, this is considered as a significant change in the terms and conditions of your non-immigrant workers' employment. Any significant change, such as a reduction in hours or salary, as previously stated on the LCA, requires prior USCIS approval and filing of an H-1B amendment with USCIS. with the appropriate filing fees. Once again, due to a lack of guidance from Department of Labor and USCIS, we ask that you exercise caution and consult an immigration attorney prior to making any changes. The last thing I'm going to cover in this video is LCA labor condition application posting requirements, both for a new job or where there is a change in an existing employee's place of employment. In general, the Department of Labor uses a good faith compliance standard in enforcing both LCA and PERM regulations. What this means is that regulations indicate that the notice must be visible to all U.S. workers. It becomes a problem when notices are posted in an office where no one is working, because then it's not visible to U.S. workers. LCA guidelines specifically state that employers must provide notice of this LCA through a hard copy posting at the actual place of business where the H-1B is employed, or through electronic notice. The electronic notice must be on the company's intranet or in its newsletter, or via direct email to all affected employees. The email can be sent only once, and affected employees are those that are in the same work site, in the same occupational classification as the prospective H-1B worker, and also include individuals employed by a third-party employer. Where employers are asking employees to work from home rather than a work site, if the work from home is in the same area as your work site location, that is the same MSA, Metro Statistical Area, this does not create a new work site, hence the employers are not required to file an H-1B amendment or post the LC at the employee's home. This is a very brief guidance on some of the major issues that our clients are facing today. If you require any additional information or clarification, please reach out to an immigration attorney. We here at Pollack, Isaac, and DeCicco are fully operational, and our attorneys are available via phone, via email, via Skype to answer all of your questions.